Um, Hello, everybody. This is James Terry Lavery, the 2020 chapter president for the Southern Arizona CCIM chapter, doing our first webinar ever as far as the chapter is concerned. We're going to be talking about commercial leasing, in particular the tenant-landlord circumstances. We have two expert lawyers here to help us through this difficult relationship sometimes that we have between the well, just with the lease itself, but also with the interaction between the tenant and landlord. First off today, we have Blythe Edmondson with Edmondson Law. Blythe, would you like to start off?
Okay, now can you all hear me? Sorry, I was muted for a moment there. Thank you. Yes, I've been representing property owners for over 20 years. I won't give my age. And since you can't see me, I pretend I look really young. But today I talked with Adam and with Terry, and we're going to focus on what COVID means for all of you right now in the commercial leasing world. I'm going to focus on the executive order that came out on April 6th, and it is in effect until May 31st. It is 2020-2021. And essentially, it is prohibiting small business evictions in Arizona. What does that mean? It means you cannot do a lockout, you cannot give a tenant a notice to vacate, and you cannot attempt to inhibit the operations of the small business in any way. What does that mean? That means largely that if a business qualifies in this group, there's not much you can do if they're not paying their rent. Your hands are largely tied through the end of May. Which businesses or which tenants does this address? Essentially the tenants that qualified for the Paycheck Protection Program are the ones that get this protection. So sole proprietors, partnerships, corporations, charity groups, tribal businesses, anyone with fewer than 500 employees falls into this category. To be clear though, again, you're not allowed to give them notices to vacate, which means terminating the lease. You're not allowed to give them notices of eviction or perform any lockouts. But if they have suddenly started running a drug den out of your property, this does not stop an eviction or a notice or anything going forward in that sense. If there is an emergency situation, we can still get in front of a judge and still handle the situation through the courts, and they will take a look at it. And fortunately or unfortunately, because the courts are so slow right now, everything's been pushed off for the most part. It's very easy to get in front of a judge very quickly right now. Another provision of this particular order is that landlords are encouraged to work with tenants and waive late fees and penalties. We'll be going over several different provisions here. Really, the only teeth that this has that is mandatory, or the requirements are that you are not allowed to evict a tenant, utilities, other things, if it's going to be forgiven. So as those regulations and rules and how the forgiveness comes down may or may not change, tenants may have more flexibility with how much money they can divert to rent and paying their landlords. But again, you're not allowed to require that they apply a certain percentage of that to what they owe you. How would you even know that they've gotten the money? You could ask, they may be vocal about it, a lot of people are, but there's nothing indicating that they are required to let you know that they have received the Paycheck Protection Program funding or SBA loan funding. So again, a lot of this does not have much teeth. It tends to sit on the surface with suggestions and options that they want people to look at. Other things to think about as a landlord, and I'm going quickly here so we have plenty of time for questions. Liability as an owner, if you are turning tenants between properties, I would recommend going in and cleaning. There are professional companies that will go in and do the cleaning for you, so that when you're renting to a new business, hopefully it's been cleaned and sanitized appropriately. Again, protecting you liability-wise for the spread of the disease. And keeping in mind, I know Adam's going to talk about force majeure and some other things. Keep in mind, some of these companies may not make it through this. So you may have some tenants that are going to be closing their doors, relocating, and some of them may make it through, but it may take them a while to get the customers back. So a lot of this comes down to business planning, what works for you. Can you suspend rent for a period of time? Can you take payment plans from them? Can you waive late fees? Looking at the type of business and how long it's going to take customers to come back. Obviously, grocery stores are doing fine. Small boutiques may or may not make it in the reopening phase. Stuff to think about, and I'm happy to answer questions as we go. And if you have any questions, contact me. Terry, are you there?
Yes, Terry's here.
Okay, that was my quick slideshow presentation.
Blythe, really quick, we do have one question that I sent to you, if you don't mind answering that.
Oh, absolutely. I'm not getting the questions popping up on my.
Oh, okay, I just sent it to you privately through the chat. Do you see that?
Let's see. No, because I have to stop sharing my screen, I think, to do that.
Okay, can I read it to you then?
Please.
Okay, this is from Dave. Can you speak to whether you think the COVID-19 crisis meets the threshold for force in lease contracts? If it's a tool to allow tenants to not meet their contractual obligations, does it apply equally to owners' mortgage obligations?
I think Adam's going to get into that, so I'd love to answer it, but I'd like to let him present his information and then go over that a little more in detail.
Hey, Blythe, I have a question.
Yes.
When do you think the Pima County courts are going to be back open?
The way the courts stand right now, they have pushed out all non-essential hearings into June. So unless if you have an order of protection, some evictions we can get through the courts. Again, if you have some sort of an emergency situation, those things are being heard by the courts, but the courts have pushed out all other non-essential hearings into the month of June. They have put out provisions indicating how they believe they'll reopen. They're going to be taking temperatures. They're going to require masks. And a lot of that information I have posted on my website or on Facebook if you want to know the basic requirements. But they are really looking at doing a slow reopen. They're being very cautious and handling a lot of things. Jury trials have been pushed off until at least June, and I'm guessing that'll be further into July, maybe August, before they get those up and running again. So the courts are being very slow with this. So again, even if we had some things we could do, we can't necessarily get in front of a judge unless it's really an emergency right now.
One more question. There seems to be some, I guess, questions concerning the difference between forbearance and forgiveness. Can you address that, I guess, for our participants today?
Forbearance means that it is, generally waived, but just for a period of time. It's pushed off. As a lot of times the payments will be tacked on at the end. Forgiveness means it is wiped out, they do not owe it. All of the executive orders that have come out, the rulings that have come out from the federal government as well as the state, and this particular executive order states, the tenants agree that they still owe rent. So it is not forgiveness under any situation. It is simply delaying payment. And again, with this order, it's encouraged that you waive late fees and finance charges, but it's not required. So the tenants still owe the rent, they still owe the full rent. Arguably, they still owe the late fees and any penalties if they haven't paid on time. You're encouraged to waive those. But they are not released from this executive order. They are not released from their liability of owing the rent. There may be some other provisions and other things in the law that would release them entirely from what they owe. But again, under this executive order, it is forbearance, meaning they get some time. It is not forgiveness, meaning the debt is wiped out.
So you're going to have it in writing, right? As far as an amendment or an addendum that's enforceable, I guess, and and it's been agreed to by both parties as far as either forbearance or forgiveness. It's not something that a landlord can just say, hey, don't pay your rent, there's no problem. You got to have it in writing.
Always put everything in writing. Document how you're doing it, have both parties sign it, make sure both parties have copies. And yes, any agreement you come to, you want to put in writing, and you want to be very clear. Again, if you're delaying the payment, allowing it to be later, you want to make sure you put deadlines on that. You don't want to leave anything open-ended. You want to put down all the details in writing.
And just because it happens in New York or LA doesn't mean it happens in Pima County, correct?
Correct, yes. What I just went over again was the executive order that applies to Arizona. What's going on in other states, unless there's some federal provision that they're discussing, does not apply here. And I'm not aware of any federal provisions right now that have come down through any of the legislation that affect us. It's really the one big legislative piece or executive piece that we're dealing with right now is the one executive order from the governor of Arizona.
Last question for me. It has to do with, I guess, the 8 million small landlords that are out there, people that just have one house, maybe one small office building. Do you have any recommendations for best practices to make it through this situation unscathed?
Residential is different than commercial. It's a whole different ball of wax. As far as the commercial goes, for the small individual, unfortunately, in both residential and commercial leasing, the landlords are taking a hit, and they're taking a hard hit. And there are a lot of groups out there that are lobbying at the federal level as well as the state level for more protections for landlords, because essentially what has happened is tenants can't be evicted through the end of May if they're commercial, and we can't get writs of restitution to remove residential tenants until late July on the residential side. And there's really no recourse for the landlord. They're stuck with a tenant in a property that's not paying, and there's nothing they can do. Again, I think one of the best things you can do is work with your tenants. If they are willing to make payments, if they are willing to work things out, do that with them. Because again, a little bit of money flow or a little bit of an agreement takes you a lot farther than trying to get in through the courts or even to do a lockout late May. The good thing, again, for commercial is it is late May, not late June, July, August, like it is in other parts of the country, or as it is with residential. So it is helpful that we're not pushed quite as far out in being able to handle difficult tenants. But a lot of it is communication with your tenants. Ask them how things are going, ask them what's going on. Again, did they get paycheck protection money? PPP money, SBA money, ask them about that. They may be very forthcoming and say yes or no. And again, if they did get some of that, you can point out that at least a portion of it has to come to you. They may try and send you $1 and call it good. Maybe they'll do a little better than that. A lot of it is just going to be communication at this point with your tenants, because unfortunately what they've done is they've just tied the hands of landlords.
Very good. Tiffany, do you have any other questions, I guess, from the crowd?
No, not at this time.
Okay, then I guess we're ready for Adam. Adam, are you there?
Partner, my more distinguished partner, Ted Hinderaker, who does a lot of work in commercial real estate, but I'm the side of the firm that does all of the litigation and more of the smaller nuts and bolts things that come up on a day-to-day basis for commercial landlords and residential landlords. Like Blythe, I'm sort of about the same vintage in terms of how long I've been a lawyer. So Blythe and I know each other, we've worked with each other and against each other, and it's always been a pleasure, and it is today. So I'll try to add a little bit to what she said, and maybe to be a bit of a devil's advocate, as if Blythe and I were in court, probably mostly agreeing but fighting with each other anyway. So the first thing, I will get to the question about force majeure because that's come up a lot. But let me see, responding to one thing that Blythe had said about the governor's executive order 2020-21, the executive order is pretty clear in paragraph 1 that it applies only to tenants that are unable to pay rent due to financial hardship. I totally agree with Blythe that the tenor, the general feeling of that executive order is that commercial landlords do not want to take any eviction, FED actions against tenants during the pendency of that executive order, which runs through the end of this month. But having said that, there are going to be circumstances, Blythe mentioned, you know, drug dealing, there are going to be circumstances where you still can take action against tenants. I've already had one, and here it is. And it gives you a sense of how there's always an exception to every rule. I have a commercial tenant in which a commercial landlord in which the tenant had arranged to vacate the premises and had in fact tendered the keys and said that they were going to vacate the premises. This was all pre-COVID, and then they didn't. They simply retained possession of the premises despite the fact that they had reached a written agreement and had tendered the keys. So my opinion about that, which I expressed to my clients, was that they were within their rights to lock that tenant out of the property. They were still making use of the property despite the fact that they tendered the keys. And I thought we had a reasonable case if we couldn't persuade them to leave, and we were able to persuade them to leave. But if we weren't able to, I felt we had a pretty good case to lock them out. And then as landlord to play defense, let them take us to court for an injunctive action to reopen the doors. So even when you think something is very clear as and pretty comprehensive as Executive Order 2020-21 is, there are going to be exceptions. And I think we do need to remind ourselves, I've been reminding clients that it applies to the inability to pay rent due to financial hardship caused by the COVID-19 pandemic. So that's one thing I would add on the executive order itself. The other big question, so maybe now I can show my face or something, but let me see if I can share this screen, because I'm going to try to answer the question now about, let's see if I can, oh gosh, how do I do this right? Okay. Can people see that?
Yes.
Okay, great. So here's a good little teaching tip. Since somebody asked about force majeure, here's an actual force majeure clause, not one that I made up for this hearing, but one that's actually in an agreement I was working on recently. This was an independent contractor agreement, so it's a little bit different than a lease, obviously, but that's kind of part of my point, because force majeure clauses, to whomever asked that question, I think it might have been Gary, force majeure clauses are contractual. And that's something that people tend to forget, because when you think about an act of God, most people kind of, I think, instinctively react, well, God doesn't follow contracts. But force majeure is a contractual provision. If it's not in writing, then there is no force majeure applicable. And if you look at a whole range of agreements that we're familiar with, all residential form contracts, I said residential, I realize this is a commercial group, but all residential form contracts for the Arizona Association of Realtors, the documents we see every day, none of them have a force majeure clause. There's a force majeure clause in some of them applicable to destruction of the property prior to closing. But apart from that, you don't see them there. If you look at commercial leases in general, it's really a mixed bag. I was looking at a lengthy commercial lease from, it was a form lease from an out-of-state, out of Arizona commercial property owner. They use this form in Arizona. And I mean, it's your typical 30-page commercial lease. For this seminar, I took a quick look at it earlier today, no force majeure clause. So even in that kind of 30-page overwritten lease, that was overlooked. So that's just by way of saying it really has to be there in order for it to be there. And then once it is there, it's contractual. It has to be followed to the letter. So if you look at this version here, number 11, that I drafted for a slightly different reason, I tried to cover the things that I thought would be relevant to this independent contractor being able to perform or not perform. And of course, because I'm thinking COVID-19, I put in epidemic and pandemic. I don't know that I've seen pandemic in many force majeure clauses. Epidemic, yes. But as you might imagine, people are adding pandemic, and force majeure clauses organically develop with circumstances. I don't think 30 years ago, our senior legal colleagues in Tucson, maybe 30 or 40 years ago, had terrorism in force majeure clauses, but it's certainly in every force majeure clause now. So that's the background to force majeure. Do I think that that COVID meets the terms of a force majeure clause? Absolutely. If it mentions pandemic or even epidemic or has some other language referencing medical emergencies and things, I think that COVID clearly meets the bar for force majeure. The problem is it has to be there, and it has to be applicable to the circumstances. So many force majeure clauses are clauses that excuse a temporary non-performance, usually on the side of somebody like an independent contractor in this case, who has to do something. Most force majeure clauses, and it would depend on the clause, most force majeure clauses don't excuse things like paying rent. And if they do, they excuse it only on a temporary basis, and rent continues to accrue. Because again, force majeure clauses tend to go to performance and not to forgiveness or even forbearance. They may result in a situation that's equal to forbearance for a period of time, but they really address the ability of the parties to perform. They arise most commonly out of employment contracts where strikes and other kinds of unrest would make it impossible for people to work. And that's really where you used to see force majeure clauses most prominently. But now you see them in a variety of places, but not always in commercial leases, as I pointed out. Does that answer the question well enough for Gary and anybody else who was asking?
I think you nailed it, Adam.
Okay, so that's what I had to say about force majeure. I was going to mention just a couple other things, and let me see if I can switch over now. I'm not an expert at this, so I apologize, but in my screen sharing, let me see if I can. Oops. Okay. Okay, this is me, so by the way, so you have my contact information, and I'm not quite as savvy with I should have been more savvy with my slides than as Blythe is, but if you can see, I have on my website a topics section, and I've dealt with a couple of things on COVID, and I'll be updating that. So anybody who wants to go to my website, which is hrtucson.com, like Blythe, I have a blog or a topics section. I'm trying to keep things updated. A couple other legal principles that come up that have been coming up in the COVID crisis. One of them, and these two sometimes get confused. I've heard a lot of people talking about anticipatory breach because some of my landlord clients have been saying that they've received unequivocal information from tenants that they're not going to pay the rent. And most lawyers who represent landlords, I think we have a kind of wait and see, proof is in the pudding kind of attitude, which is, well, lots of people say things for negotiating purposes, but what really matters is what they do. And so just because someone says they're not going to pay the rent doesn't mean they're not going to pay the rent. And maybe they'll pay it late. That's what late fees are for. That's what interest is for. But they may still pay it. But some people have said to me, nope, this is different. We're in a crisis. This is COVID. And I have people saying to me, they are not going to pay, period. Well, that is a concept called anticipatory breach. I think most of you are familiar with it. It's a little bit of a gray area, or a kind of it's a little bit of a hard to figure out exactly how that is different than breach. But anticipatory breach is when somebody says unequivocally in advance that they're absolutely not going to perform and there's no reason to pursue them. What that allows a landlord to do in normal circumstances is to accelerate their ability to go after that, tenant for collection, because they've made it clear that they're not going to perform in the future, and they've done that unequivocally. A lot of people have asked me, should we be exercising anticipatory breach, our rights in an anticipatory breach? And these rights are common law rights that are well established in Arizona cases. I'm more than happy to give people some citations to the cases, but I thought I would avoid that for today. My answer to that question is, you do not want to be pursuing people for anticipatory breach at this point. It's a bridge too far. In the best of circumstances, it's hard to prove because there's always a possibility that the person is going to come through and pay, and maybe pay some penalties or late fees. But given the governor's executive order, now is not the time to be trying to accelerate damages, even if we wait until the putative end of this executive order, which is May 31. Now is not the time to be accelerating damages on the basis of anticipatory breach. So some of my zealous landlord clients who have been asking about that, I've put them off and tried to direct them back, just as Blythe did, to more constructive, working with the tenant solutions that will maybe help to bring in some money and keep the tenancy in place, rather than take us to court now or after the executive order has expired. The other legal topic that's been coming up is something called commercial frustration. And that's been coming up more from some of my tenant clients who've been saying, look, I don't care about force majeure or anything in my lease, because I may have pointed out to them that there is no force majeure clause in their lease. What they're saying is, look, this is just black and white. I can't perform. I don't have any money. I'm out of business, and there's nothing I can do, and it's not any fault of my own. I'm a restaurant. I've been closed. There's simply nothing I can do. And that concept in the law is called commercial frustration. And once again, in normal times, it's a hard one to prove, because that tenant who's absolutely shut down through no fault of their own, has no savings. You're not required to have any savings or reserve fund as a tenant, right? I mean, if you live day to day, and if you don't have any income, you don't have any income. And if you've been shut down by the governor, that's certainly not your choice. So commercial frustration is a hard one to prove, because you got to show not just that you're out of business and can't perform, you have to show that it's really impossible to perform. No, in other words, nobody could perform. You may have the ghost of a chance of proving that, where restaurants are completely closed down by a governor's order, but generally it's not a productive way to get yourself out of a lease obligation, because the bar of proof, the bar for proof is so high. So on both sides of the coin, I've been saying to my landlords and to my tenants, these get out of jail free cards that do exist in the law, such things as anticipatory breach, commercial frustration, they're probably not the best way to go in this situation. And so I've been trying to talk both landlords and tenants down a bit, very much in the same tone that Blythe was using in her presentation. Any questions at that point?
Yes, I was wondering, as far as the commercial frustration, there's another topic that kind of came up last week in another webinar that had to do with practicality. And the concept that whatever they're leasing at this point doesn't make business sense to them to continue to pay for. And it has to do with maybe having 10 people in a 1,500 square foot space. They're just kind of coming and going, but they can't do social distancing anymore. They can't, all fit at a small 4-person conference table because of social distancing. They got issues as far as just, density, as far as how many people they can fit in a small space. There's a lot of impracticality that the pandemic brought on. I was just wondering what your thoughts were, Adam.
Well, I think that practicality issues, and Blythe will definitely have more to say about this, practicality issues really don't matter. If it comes up to the level of commercial frustration, impossibility. So, for example, if we had a governor's order that said everybody must, people performing a certain kind of work, let's just say they're operating a lathe, people operating lathes must be spaced out at 20 feet. Well, if your space is 15 by 15, then I think you probably are commercially frustrated at that point. But I'm not aware of any legal principle of impracticality that you can invoke. You've got to either crank it up to the level of commercial frustration, or it falls into the category of negotiation with your landlord, and you have to start making some concessions on both sides. And one anecdote that's already come up, because I'm trying to stick to things that have actually happened. I have spoken already to one tenant of mine who, and this was kind of an interesting situation they found themselves in. They have commercial lease, pretty standard, as I said. They have, I think, 3 more years on that lease and then a 3-year option. What they've learned is, and they're still in business and they're still doing reasonably well. They have their problems, but going out of business, commercial frustration, force majeure, those are not things that they're worried about. What they're noticing is that, and I think we're going to hear a lot of this in the negotiation side, their employees are so happy working at home that they don't want to come back. And they're realizing what they could have realized probably years ago, but didn't worry about realizing because commercial real estate was relatively cheap for them. They don't need the space and they don't want it. And what they really would like to do, and what would be most beneficial to them, is to renegotiate that lease now so they can have less space. And that's where I sort of circle back to where Blythe ended. When I, discussed options with them, obviously the lawyer's answer is going to be, look, you're bound to this lease. There's nothing, you've got no way out of this lease. It's a commercial lease. What you can do is talk to the landlord. But if I were representing the landlord in that situation and the tenant came to me, and this is a good tenant, an international business tenant, so they have prospects and sales all over the world. If that tenant came to me and I represented the landlord and they said, look, we understand you don't have to do anything, but we don't need this space and we're never going to need it again. And we'd like to negotiate a reduction in space. As the landlord's lawyer, I would say, well, what do we get? What's on the other side of that? Because extending that lease, getting some other forms of lease guarantees, greater security perhaps, could be worth it to the landlord. Because I think we all know, this is a sophisticated group. Landlords who enforce their leases to the letter always risk, particularly in uncertain times, shooting themselves in the foot. Just because you can do it doesn't mean you should do it. And I can easily see a scenario, perhaps maybe in this case, just because I'm representing the tenant, I can easily see a mutually beneficial scenario where my clients downsize now, make certain other concessions and agreements to the landlord over the longer term that are beneficial to the landlord. The landlord goes about trying to rent that extra space. Granted, not the best time to be doing it, but on the other hand, is it better than my clients paying the, there's actually happens to be an out clause in this lease. Who says my clients aren't going to raise the money, buy themselves out of this lease, or simply default? Who says they're not going to declare bankruptcy? I know they're not, because I know they're not. But the landlord really needs to think about whether the negotiation is over just because they've got the lease that they wanted 3 or 4 or 6 years ago in a different financial climate, or whether the negotiation goes on. I think a lot of people remember, I know Blythe does, Carmen Cornelio, the judge, the Superior Court judge in Tucson, is now a arbitrator, mediator. And I was in a settle conference. He was, obviously a pretty colorful guy, still is. And I was in a settlement conference with Carmen, and I kept making the argument that I just said you shouldn't make, which is, we're the landlord, we've got the lease. It's in black and white, we're right, they're wrong. And Carmen says to me, Adam, you got a lease for a year, you got a lease. You're the landlord, they're the tenant. A year lease, that's a lease. You got a 10-year lease, that's a business partnership. And you got to work with these people. I mean, being right is not going to help you. And so I think that advice comes back to me a lot. Being right is not necessarily going to help commercial landlords in this climate where circumstances beyond all of our control have kind of reopened negotiations that most landlords hope were closed.
Hey, Adam, one last question. I have a tenant that hasn't been around for about 30 days, and they have a clause in their lease as far as abandonment that has to happen, on the 31st day, as far as some notice you have to give them. Have you seen a lot of this going on as far as people who are like doctors or therapists who are just doing it through the internet, like we're doing this webinar, and still conducting work, but they're not doing it in their space?
That's a great point. Most of those go dark clauses in commercial leases, they first of all, there's usually some carve outs in those that talk about taking inventory and things like that. I don't know how applicable that is to professionals like doctors. So first you have to really look at the carve outs in those go dark clauses. And then secondly, those are almost always notice clauses. So it's very rare in commercial leases that I'm familiar with that you don't have to give usually pretty significant notice of that breach, which of course is curable. So I think that the terms of the lease will probably take care of itself there. Usually you've got 10 to 30 days notice to a tenant who has quote unquote gone dark. And sometimes that's, if it's a good lease, that's defined in the lease what it means to be dark, not operating during regular business hours for a period of 14 days or more, something like that. So usually when you give that notice to the tenant, which you're going to have to give, you're going to get some sort of response that I think will answer your question, Terry. Someone's just going to say, look, we're operating remotely because of COVID. We'll be paying the rent. Don't worry about it. And that is probably going to answer your question for you. If they're not paying the rent, then you've got a whole different problem that, the fact that they're going dark becomes less relevant because that falls under non-payment of rent, which is almost always in a good commercial lease, a default that doesn't require any notice to cure. Some weaker leases provide for notice on a monetary default, but they shouldn't. A good lease shouldn't. And of course, as Blythe was already pointed out, you can't take any action against someone who's not paying anyway, at least not now. So your hands are tied. But I think that in that situation, you want to give the notice, probably give it in the friendliest way. And, by saying, I notice that you've gone dark. I mean, is there anything I can do to help? Are you working remotely? Can you fill me in? And I think you'll get your answer. You'll get your answer from that. If the answer is, well, yes, we're dark, but we're really out of business and not paying, then you're thrown back on Executive Order 2020-21, and you have to wait and see what happens in the future.
I agree with Adam, and I just wanted to add, I think, again, when it comes to actually getting in front of judges and in front of courts on some of these things, I think they're going to be a little bit lenient on some of those types of clauses. I think they're going to look at that and they're going to say, yeah, but it was COVID. People had to work remotely. They had to. I think they're going to have a hard time, even if it's letter of the law, enforcing that kind of thing, which goes back to what Adam was saying and what I was saying, that you just have to negotiate and work with your tenants. So it's a negotiation back and forth, and just discuss it with them.
Yeah, that's a better way of saying what I meant to say. I can't see any reason why you're going to hardcore terminate someone on a go dark clause when they're paying the rent. You might do that in a booming economy where you have a sort of annoying client who pays the rent, but it often goes dark for whatever reason. You want to get rid of them, putting in a better client. But those days are not, those aren't the days we're living in.
Tiffany, do you have some questions for our panelists?
I'm not Tiffany.
No, none has come up, but everyone's unmuted, so people can chime in if they want.
I have a question here from Craig, and the question was, did I hear Adam or Blythe say that the governor's order to not lock out do not apply to large chains? What is the cutoff? The executive order, again, applies only to businesses that qualify under the federal order. So the state order is referencing the federal order as to which tenants it applies to. Because the federal order was broad and has been narrowed down a little bit in that they're not allowing publicly traded companies to fall into that category, we're still looking again, if it's a chain, as in it's a franchise, they're probably going to go ahead and be protected by the executive order. If it's Amazon, they've got more than 500 employees, they're not going to be protected by the order. But again, McDonald's, those tend to be chains and franchises, and they tend to have fewer employees, so they're probably going to fall into that safety category. But it depends on the specific business, and I'd be happy to help you look if you have a specific case, or I'm sure Adam would too, as to whether or not the business qualifies under the executive order.
Yeah, I agree with Blythe on that. I think what we know is what it says. I mean, what I wrote on my website, which you can, as I said, everybody's free to take a look at that. I kind of went with the you don't want to touch commercial businesses right now for non-payment of rent. It's just going to be more hassle than it's worth. But there's an exception to every rule, and that's why we have litigators like Blythe and myself. And if you really are getting stonewalled by Amazon, you've got, you certainly do have a case, and I would look at that on an individual basis. But I mean, we should all be so lucky to have Amazon as a client right now. I think Amazon supermarkets, as Blythe said, I mean, they're the ones who are doing well.
So, Tiffany, did we open up any new questions for Blythe or Adam, excuse me?
None that have come in.
Okay. Well, we promised everyone we'd have this thing done in 45 minutes, and I got 12:46 here, so we're just 1 minute over. I really appreciate both of your input as far as the tenant and the landlords are concerned, and what's going on as far as Pima County. It's very, I think, educational for our chapter to have questions and answers that are Pima County specific as far as tenant landlord issues are concerned. I think that's what makes it interesting as far as we're concerned. So we appreciate both your times, and we'll get back to you if there's further questions. I think one just came in. Hold on.
Oh, yep. You got it, Terry.
Oh. Thank you. Excellent and informative. Oh, we're getting those kind of answers. We love those. So, all right.
Yeah.
Well,
Anyway, that must have been for Blythe.
Oh, Adam, come on. We do well together.
Yes, Adam, you got unbelievable FaceTime in that black turtleneck that you had.
Yeah, sorry about that. I kind of was having trouble just getting rid of it, but I figured out how to do it.
Well, you looked like a Frenchman. You see, you had the language of French, as part of being able to speak. So, anyways, I appreciate both of your time. Thank you very much.
Yeah, and just so everyone knows that this recording will be made available. We will get that edited this week and sent out to everybody that attended. It's good information. We'll send it out to you as well, Adam and Blythe, just so you have it. And thank you again for doing this.
My pleasure.
Thank you all.
All right, take care.